One of the key responses to the COVID-19 pandemic was the act of mandating hotel quarantine. The government was able to do so through the exclusive legislative authority granted to the Parliament of Canada under Section 91 of the Constitution. These powers allow the Parliament to enact laws for the peace, order, and good government of Canada. Subsection 11 of Section 91 grants powers in relation to quarantine. Under this section, the Quarantine Act of 2005 was established. Section 58 of the Quarantine Act was invoked in order to mandate hotel quarantine. The rules established under this act included requiring all travelers entering the country to quarantine for 14 days, ensuring that all travelers take a mandatory COVID test upon entry to Canada, as well as prohibiting symptomatic foreign nationals from entering Canada. There are some exemptions to mandatory hotel quarantine, including individuals who are fully vaccinated, travelers who work essential jobs, and those who regularly cross the border for work. In order to ensure compliance with the rules for individuals who do not fall in these categories, there are hefty fines and punishments. This is pursuant to Section 67 and 69 of the Quarantine Act. Under Section 67, those who break mandatory quarantine could be subject to fines up to $1 million and/or imprisonment to a term up to 3 years. Pursuant to Section 69, those who violate any instructions provided to them upon entry to Canada could face up to 6 months in prison and/or up to $750,000 in fines. The federal government amended the Contraventions Act to include Schedule 16, which allows officers to enforce these provisions under Section 58 of the Quarantine Act by allowing officers to issue tickets to those who are found in violation of these provisions. In this case, a group of Canadian applicants traveled abroad during the COVID-19 pandemic. On their return back to Canada, they alleged that mandatory quarantine contravened with their rights under Sections 6, 7, 8, 9, 10, 11, and 12 of the Charter of Rights and Freedoms. The applicants alleged that any benefits that may arise from quarantine were not justified in a free and democratic society. The court dismissed the case, the reasoning behind it being that any harm to the applicants was not a sufficient basis to suspend a significant public health measure. However, there was one exception to this ruling. Here, the applicants were not properly informed of their right to retain counsel, and border control officers refused to tell them the location of their designated quarantine facility. It was found that this incident breached Sections 9 and Section 10, subsection 1b of the Charter of Rights and Freedoms. Due to this violation, a new requirement arose which allowed travelers to book their own hotel reservations and ensured that border control officials informed travelers of their right to retain counsel. During the COVID-19 pandemic, there was a great deal of job loss and financial strain on Canadians. In response to this, the federal government provided many different economic support payments. One of the first of these payments was the Canada Emergency Response Benefit. These payments were created in order to support individuals who experienced job loss as a direct result of the pandemic. In order to be eligible for these payments, applicants had to meet the minimum requirements set by the government. The government was able to provide these payments due to the legislative authority granted to the Parliament of Canada under Section 91 of the Constitution. Under Section 91, subsection 2A, the Parliament is able to create laws in relation to unemployment insurance. Under this section, the Unemployment Act 1996 was created. The government amended this act in order to include provisions for CERB and consequent support payments such as CRB. However, the funding for these payments comes from the federal spending budget, which allocates specific amounts for payments such as EI. As seen on the figure to the right, the federal budget was increased in 2021 in order to accommodate for economic support and recovery payments as a result of the pandemic. Legal positivism explains law as being commands created by a sovereign which can be enforced and are backed by sanction. When examining the issue of hotel quarantine and the use of police officers in order to enforce this legislation, we're able to see this concept come to light. Legal positives would agree that hotel quarantine is a valid law as it meets all the criteria of being a law. As the sovereign, the government, has the ability to enforce these laws through the use of police, and violations of these laws are met by sanctions in the forms of fines and imprisonment. The issue that legal positives may have is the underlying moral obligation behind the laws, as legal positives believe that law and morality should be separated. Here, legal positives would question the validity of the law as it raises the question of whether there is a moral obligation to ensure that others do not get sick. Examining the second issue in regard to economic support payments, we are able to see critical legal theory play a part. The overlying theme of critical legal theory is that the privileged are favored over others and that the law looks after these individuals. The critical legal theory focuses on creating a legal system where there is no class and those that are privileged are not favored. When examining the economic support payments given by the federal government, we are able to see how critical legal theorists would approve. By providing the unemployed individuals with money, it is ensured that those that are not employed are not placed at a disadvantage to their employed counterparts.
Now I'll be discussing a timeline of events following Ontario's issuance of state of emergency on March 17, 2020. After the issuance of state of emergency, Ontario closed businesses and retail stores. Businesses were not later opened until May 4th, 2020, and retail stores began opening May 19th, 2020. Following that, many individuals refused to get vaccinated, so Ontario began asymptomatic testing on May 24th, 2020, as well as opening more testing centers. Then, on June 19th, 2020, restaurants and dining began opening, and masks became mandated on October 3rd, 2020. From November 3rd to 14th, Ontario recorded consecutive record-breaking numbers of daily new infections across the province. And this also led on December 4th to Ontario's ICU capacity peaking at 203, with a threshold of 150 being known as a critical mass. This led to a province-wide shutdown on December 26, 2020. After that, on January 12th, Premier Ford issued a second declaration of emergency, and additional stay-at-home orders were also announced, and non-essential businesses were only allowed to operate from 7 a.m. to 8 p.m. After that, April 15th, Ontario began remote learning for public school students, so they were not required to only attend classes in person. Then, on September 4th, 2021, Premier Ford announced vaccine certification systems. This required two systems. The first system was the vaccine certificates that were rolled out, and now he has rolled out vaccine QR codes. As mentioned previously, Ontario had declared a state of emergency on March 17, 2020 under the Emergency Management and Civil Protection Act. The Reopening Ontario Act, which is the main act we'll be looking at, was enacted on July 21st, 2020. This act can be amended in response to the changes and fluctuating risks from COVID-19. These regulations may only be extended or amended to a maximum of 1 year. However, this may be further extended depending on legislations. Some examples of regulations under this act include steps for reopening. Ontario is currently in step 3, and we will be further discussing this later. Patios, which is defined in the act as an area that is not an enclosed public place or an enclosed workplace, and they have become very popular during the pandemic since it has minimized the risk of COVID-19. A patio under this act also needs to meet 3 of the following criteria. First, the public must be ordinarily invited or permitted access to this location, either expressly or by implication. Next, the food or drink is served or sold or offered for consumption in that area, or the area is apart to another area where food or drink is served or sold or offered. Lastly, the area, it cannot be primarily a private dwelling. A regulation under this act is enforcement orders. This gives police officers or any provincial officers, according to subsection 1 of the Provincial Offences Act, the power to obtain identification from individuals where they believe on reasonable grounds have committed an offence against this act. And the last example is management of retirement and long care homes during the outbreak. Retirement homes and long care homes were greatly affected during the pandemic in Ontario due to their vulnerability to the virus and high case numbers. These regulations ensure that even if one resident or staff member tests positive for COVID-19, orders can be made immediately to handle the situation. Okay, now I'll be talking about the current step that Ontario is in, which is Step 3. Ontario entered Step 1 and 2 on June 11th and June 30th, respectively, and which were both earlier than planned. Step 3 was entered on July 16th of 2021, and this was last amended on November 18th, 2021. Step 3 includes closures, such as closures for retail stores and businesses, proof of vaccination, which has been rolled out in 2 stages, first being the vaccine certificate and the second being the QR codes. And it also includes capacity restrictions, mask restrictions, and social distancing restrictions. Now I'll be discussing capacity limits under Step 3 of this Act. Capacity limits for indoor businesses or facilities are limited to allow a 2-meter social distancing between individuals. This can be a maximum of 50% or 25% capacity according to the Fire Protection Prevention Act of 1997 and depending on the type of business. Now, looking at positivism theory, positivism insists on the separation of law and morality. It can be argued that this law of capacity limits takes away the freedom of choice from individuals and makes it difficult for them to have more customers. As it was seen during the pandemic, many smaller businesses were going out of business and facing financial difficulties due to these capacity limits and closure requirements. Now I'll be discussing the case of Dineshwar in Ontario. Dineshwar argued that his computer skills and other restrictions make it difficult for himself and people like him to get vaccinated. He provided his own statement and 3 affidavits from others stating that it's difficult for vulnerable people to get access to the COVID-19 vaccine. He argued that the vaccine should be distributed equally according to Section 7 and 15 of the Canadian Charter of Rights and Freedoms and Section 1 of the Human Rights Code. Section 7 is that everyone has a right to life, liberty, and security of the person and the right to not be deprived thereof. Section 15 puts every individual equal before and under the law and without discrimination, in particular looking at based on race, national or ethnic origin, color, religion, sex, age, mental, or physical disability. It can be argued that Dineshwar took more of a natural law approach because he looked beyond just the rules and procedures and argued that there's a moral obligation on the government. However, the government responded that Dineshwar brought up important issues, but it was dismissed for 2 reasons. These reasons include that he did not mention the relief he seeks, and he did not establish that there was actually any difficulties for him to access a vaccine. There was also not a breach of the Charter rights because Ontario does not have a duty to provide vaccines to Ontarians. However, the Public Health Unit does.
So I'll be talking about the Peel Region's pandemic response. First and foremost, it emphasizes the importance of following the Ontario's health and safety regulations for the gradual 3-step reopening process. The Peel Region anticipates that by November 15, 2021, capacity limits in high-risk locations will be lifted, such as nightclubs, strip clubs, and sex clubs. By January 17, 2022, the capacity limits will steadily be lifted where proof of vaccination is not required. Moreover, proof of vaccination requirements will begin to ease. By February 7th, 2022, proof of vaccination requirements in high-risk locations should be lifted. By March 28th, 2022, remaining public health and safety measures should be lifted as well as proof of vaccination requirements. Moreover, public health measures may be applied locally, such as capacity limits, physical distancing, gathering limits, proof of vaccination requirements, and more. Now I will briefly mention the Health Protections and Promotions Act of 1990 and how it relates to the Peel Region. Section 22 allows a medical officer of health to require someone to take or avoid taking action with respect to transmittable disease. Moreover, face coverings class orders were issued on September 18, 2020, but was amended to include common areas on March 15, 2021.
Now I'll be talking about the orders issued in Peel Region in relation to combating COVID-19. The letter of instruction for indoor organized sports was issued on October 15th, 2021, but effective on November 1st, 2021. This meant that owners or operators of a business or organization in Peel with indoor spaces for sports or leisure fitness had to ask people above the age of 12 to provide identification and proof of vaccination or valid medical exemption upon entry. They also had to apply and ensure compliance of the Reopening Ontario Act, the Ministry of Health's proof of vaccination guidance for business and organizations, the letter of instruction, and local municipal bylaws of masking. Failure to comply resulted in a $750 fine for each person, including victim surcharges, or $1,000 for corporations. The Section 22 order issued for Chandani banquet halls was that Peel Public Health issued this on October 6, 2021 to enforce COVID-19 requirements under the Health Protections and Promotions Act. The Section 22 class order for workplaces said that Peel Public Health issued an updated class order under this section of the Health Protections and Promotions Act for workplaces in relation to COVID-19. Workplaces had to send anyone home to self-isolate who had COVID-19, had symptoms of COVID-19, or expecting COVID-19 test results, or in contact with someone with COVID-19. If 2 or more cases of COVID-19 were found connected to a workplace within 2 weeks, it had to be reported and close contact had to be investigated. Interventions by Peel Public Health during outbreak investigations and closure is also permitted under this bylaw. Failure to comply with the order results in a fine of up to $5,000 and may be liable on sentence of a maximum fine of $25,000 each day of the offense. Section 22 class order for self-isolation meant that Peel Public Health issued another updated class order on October 14th, 2021 under this section of Health Protections and Promotions Act. Residents or visitors of Peel needed to self-isolate if they have COVID-19, signs or symptoms of COVID-19, awaiting COVID-19 test results, or in close contact with someone who has COVID-19 or its symptoms unless they're fully vaccinated. Peel Region also offered help to its residents during isolation, such as food, water, medicine, and more. Now I'm going to be talking about Ontario versus Adamson's Barbecue. After just 1 day of Peel Region entering the grey lockdown zone of Ontario's reopening plan, where indoor and patio dining were banned as a response to COVID-19, Adam Skelly, the owner of Adamson Barbecue, defied the order and received a fine from the city. Thus, he infringed on Section 9 of the Reopening Ontario Act and was given a restraining order to prohibit him from defying the act. Among other issues, this raised questions about whether the recuperating of costs by the municipality from a protest is constitutionally valid. Adam decided to seek remedy under Section 24 of the Constitution. He challenged the constitutional validity of the ROA and whether Section 1 justified this. He argued that his rights under Section 2, 7, 8, 9, and 15 were infringed by this act. However, this notion must be provided in a notice of motion, and the alleged unconstitutionality was deficient in the notice, so that the damages for the charter could not be provided due to lack of proper civil procedure. This case, however, is still important because the constitutional issues raised should be further investigated, especially Section 2, as it protects civil disobedience in the form of protest. However, in this case, the Adams protest incurred municipality costs in the fine for his actions as well as arrest. Moreover, his argument of Section 7 to include economic stability as part of security of a person is interesting, as this society is based on a capitalist survivorship.